Somebody just temporarily cut me off. The committee has called to order in public, returning in public session, following our deliberations in private. Are there any motions at this time?
Yes, Mr. Chair. Move myself, be it resolved that upon hearing the representations and reading the written submissions and documents submitted by the applicant, the candidates, the representatives, and the committee hereby rejects the application because it was not presented with compelling and credible information, which raises a reasonable probability that a breach of the campaign finance provisions of the Municipal Actions Act has occurred. The submissions presented on behalf of the candidate were persuasive and supported by cogent documentation. These submissions addressed the concerns alleged by the applicant.
Thank you. All in favor? Opposed? Motion carried. The next item for business on the agenda is an application concerning the candidate Jay Tysick. I hope I pronounced your name correctly, sir. Thank you. Does the applicant wish to make any comments on his application? The candidate's indicating in the negative. I'm sorry, the applicant. Okay. Does wondering if we can ask him questions even if he doesn't say anything. I guess so. Do members have any questions of the applicant? No? Does the candidate wish to make any submissions? Mr. Tyson?
Thank you, Mr. Chairperson. And I thank you for setting up at the beginning of this meeting the test by which you would be considering these applications. I also would like to thank Mr. Leeds, who appeared before, for adding additional clarification about what reasonable grounds is defined as. And I think my submission at this point is that the application contained no reasonable grounds. There was 2 points that the applicant had made, one being that I had run in a campaign which incurred expenses. I don't believe that was in question. I don't believe anyone is believing that didn't happen. I admit that. And the second point was that I failed to file Form 4, which is a submission of my expenses, which again, I don't believe anybody is questioning. That's a fact. The Municipal Elections Act actually has a prescribed penalty for failing to file. And that is that I would lose any office I had been elected to, and I'm prevented from any appointments or running in the next election. That's fine. I accept that penalty. It's already been assessed against me, and so I can't see in the material that was submitted. There's no grounds whatsoever to believe that there was any wrongdoing. in that I ran an election and there was expenses incurred. My campaign was largely unspectacular. It was a normal campaign. I did have signs, I did have a website, I did have these things. As for failing to file, I mean, I've already been assessed that penalty, so I can't see any grounds presented, and I can't see any interest to this committee or to the public in general in pursuing this further, as I've already accepted that penalty and I'm not contesting it. That's my submission. I thank you, and I hope that you find the same.
I have a question of staff.
Staff?
Even though the candidate has been provided with a notice of default, does the candidate have any ability prior to the next election of going to the courts and asking to be excused from that default?
Thank you, Ms. Bergeron. The candidate does have the ability to petition the courts for an extension of time to file financial statements, if he chooses to do so.
Mr. Chair, may I ask a question of our
Yes.
committee counsel? Or the city clerk, I'm either or. There is an automatic penalty for failing to file. Is that automatic penalty necessarily the complete and only judgment that can be made, or there is an admitted infraction of the Act?
Mr. Chair, the penalty is in effect now. However, obviously leading up to the next election in 2022, there would be an opportunity for the candidate in this instance to go to a court, petition a judge to remove the penalty from him, and that is done on a regular basis. I would say it's happened in the last 2 or 3 elections that I've run.
Just to follow that up and be more specific then, would there be, based on the admitted breach of the Act infraction, is there any grounds for this committee to call an audit for an audit? Does one cancel the other?
Thank you very much, Mr. O'Callaghan. The simple point is that having transgressed the requirement of filing under the Act is not a defense to not following campaign finance rules. They both look at different things. So your mandate is with respect to proper compliance with campaign finance rules with respect to income and expenses. The fact that somebody doesn't file their financial statements is no defense to that, and it's no answer to it, respectfully. So you do still have jurisdiction under Section 8833, sub 1 of the Act.
Just let me just confirm that for we still do have jurisdiction to call for or to go to the next stage and ask for an audit.
If the committee is persuaded that there are reasonable and probable grounds in accordance with the articulated test in the jurisprudence to find that an audit should be ordered, then you do, yes.
And the failure to file, would that be a reasonable reason? Is there? Surely we have. Surely we can believe that there's a reasonable. Since the infraction has been admitted, we don't even need to look at reasonable. I mean, it's admitted. Is that sufficient in itself then to proceed with an audit?
I would say that's up to the committee to decide.
Okay.
I wouldn't want to suggest an answer to what the committee's decision
all right.
should be.
Let me phrase that better. The fact that there is an automatic penalty assessed does not mean that the committee cannot consider this matter.
That's correct.
Thank you.
Mr. Chair, I have a question for the candidate.
Yes.
Mr. Tysick, can you tell the committee what's the reason you don't want to file a financial statement?
Yes. And I thank you for the question. In truth, I'm just going to speak for a moment about the test. The test is there reasonable grounds? And then I will answer your question. The test, though, here is there reasonable grounds to believe there was contravention of the Election Finances Act, as has just been explained, that failing to file in itself is not evidence of that. I believe that there is no grounds, and the question of why I didn't follow or file isn't necessarily material to that question and test. However, since you asked, I am happy to answer it. I didn't include it in my original submission simply because I didn't feel it, like I said, was material to the test. However, during the course of my election, and I'm going to be careful about what I say here. You've asked me my reasons, so I'm going to speak to my opinions and my experiences. I'm not providing a testimony under a court of law. Is that fair? There was a lot of misdeeds that I saw by my opponents and those surrounding my opponent. There were things like my tires were regularly popped in my car. There was people that I was meeting at their doors saying that they had been intimidated by the opponent. There was people who had taken my sign and then removed my sign and told me the reason why they got phone calls that was challenging them, saying, you know, if you support Jay and Jay doesn't win, you could be in real trouble. And so things like this as well. There was a newspaper report from before the election in late October where a well-known member of the community, a former councillor, had indicated that he'd both been physically and verbally intimidated into supporting my opponent as well. Since the election, I've heard that there is an investigation ongoing into the possible abuse of office that led to harassment of members of the community who did not support, and that investigation is still ongoing. If I were to file, I believe I would simply be providing an additional list of names to be added to this, for lack of a better word, hit list. Now, I understand that nothing has been proven at this point, but I reasonably believe there is enough risk to want to protect those people from any potential harassment or threats or intimidation. I fully expect that the committee or the investigation that's being conducted will come back with some kind of answer. It will either be that this thing has not occurred, in which case I would be happy to file and provide those names of my donors, or that it did occur but actions have been taken to prevent it from happening again, in which case I would also be happy to file my forms, which would include a list of my donors. But at this point, I can't see why there would be incentive to do so. Is that a fair answer,
Yeah,
Mr. Chairman?
thank you. Yeah.
Any further questions of Mr. Tysick? Vice Chair Bedard? Any further questions of the? No further questions? Any further questions of committee, of support staff? In that event, are you ready for the question, or would you see the need for deliberation?
Yes.
Need for deliberation is expressed. We will deliberate in private, returning here in 15, 20 minutes. We're adjourned for in-camera discussions, deliberations.